could stand up on a constitutional challenge. It's something that's focused not on guns, but on helping people when they need help the most. So that's where the committee came in, the Judiciary Committee, and we started meeting. The players who were involved in those discussions were some of the most respected legal minds in our state. Then Senator Carpenter, now a probate judge, who chaired the committee, was originally in favor of red flag, led the negotiations along with Derek Langhauser, who now teaches at the university, teaches law. Let me just shut this off before I cause trouble. Not only Derek Langhauser, but Brian McMaster, who just retired from Attorney General's office, John Chapman, a very strong pro-Second Amendment attorney out of Portland. Together, along with Senator Kine, who sponsored the so-called Yellow Flag Amendment, we began to meet, and we met for almost a month and came up with a bill that we believed met constitutional muster. This is how our system works. When the legislature says they want something, you can either engage and try to mitigate any negative impacts, or you can stand on the sideline and live with what they come up with. When we injected ourselves into this process, me, Sam, we knew our goal was to first protect public safety, but more importantly, if we did pass a bill, that it would protect individual freedoms, particularly due process. So that's where this started. That bill did get passed, and I think Senator Kine just came in. Any legislators who want to come up front when things are happening, I'd love to engage during this presentation. The two people that are here today are under invitation from us who deal with this law every day. Michael Johnson, I believe.
Yes.
Yes. Their troop, or their division, has conducted more yellow flags than any other in the state. He'll be speaking to that in a minute. But I think the real asset to us here today, both their knowledge, experience, but Mr. Strick actually conducts, or his Spurwink company conducts the mental health component of yellow flags. This is your opportunity to learn the facts about how the law works, to put aside the political talk and rhetoric that you hear outside of this place. These people know how the law works. They deal with it every day. So now's your chance. You want to learn how it's used? This is your opportunity. So with that, I'm going to turn it over to one of you to begin your presentation, and we'll take questions at the end.
Thank you, David. Maybe some introductions, a little bit about myself, and then Ben can talk a little bit about himself before we get started. So
Could you just use the podium?
Sure,
Thank you.
sure. Good morning. Thank you for having us. Michael Johnston, I'm a lieutenant with the Maine State Police. I'm commander of the Northern Field Troop. So I oversee uniformed state police operations for a 4-county area: Penobscot, Hancock, Washington, and Piscataquis. So I think we'll talk about some numbers in the application of this law, but just so you kind of know why I'm here. So since this law has been in effect July 1st of 2020, the state police have successfully used this law 61 times. That's more than any other law enforcement agency in the state. And my troop has done 37 of those 61. So my troopers have utilized it a lot, particularly post-Lewiston. So I've been with the state police just over 23 years, and in that time dealt with various policy, legislative issues, and obviously now I execute those operationally with my troopers in the Northern Field Troop. Let Ben introduce himself.
Hello, my name is Ben Strick. I'm the Vice President of Adult Behavioral Health for Spurwink Services. We provide 24/7 telehealth access for the weapons restriction assessments, the assessment by medical practitioner component. As of last night, we've done 642. David has thankfully posted all of the assessments from the most recently published list, so you're able to see those. To be clear, I'm not here to take a position on one side or the other. but I'm able to answer any questions that you might have about how the process works, what we've seen, and collaboration with law enforcement. We have a presentation. We kind of have two general presentations that we give. One for law enforcement on how to use it, another for the general public on how the law works. This is a bit of a hybrid between the two. We're not going to follow the slides religiously, but we may use it as a guide. And then I think I just had to add this slide.
Thank you, Ben.
Charlie?
So this is the first time we've co-presented, although he's a pro. I've seen him present many times before, so hopefully it's not, it's seamless. So Ben mentioned some of the numbers, and I think that's important because when I teach this primarily to law enforcement, but I think this is true for everyone, we live in a post-Lewiston world for all that means. And when I look at it from a law enforcement perspective, what that means in terms of our public safety responsibilities, but certainly with respect to the application of this law and the importance of this law. So I think my numbers are correct. I think we successfully utilized this law from July, when it went into effect, July of 2020, up until the Lewiston incident. It was successfully used 81 times. Since then, I think it's been used 609 times. So Ben mentioned that what Spurwink has done, and they're the lion's share. They were a game changer. But overall, it's been 690 times, and 609 of those have been since Lewiston. So 3.5 years, 81. In the last less than a year and a half, that's the numbers you've had. That's unbelievable. And I think that speaks to the application of this law, the law itself, law enforcement and medical practitioners in the community buying in to the public safety aspects of that, and that's why you see so many. So that kind of sets the stage for when I say we're in a post-Lewiston world. And we're really going to talk about kind of the nuts and bolts of this law. I'll try not to get into kind of too much in the weeds in terms of law enforcement, but I'm certainly open to any questions you have about that process. But kind of the nuts and bolts specifically related to what protective custody is, probable cause to get to protective custody, and the importance of relying on third-party information as part of the application of this law, which would be all of you folks. Before I do that, though, sometimes I find it's helpful to clarify when you talk about mental health and firearms. And I know I'm speaking to an audience of sportsmen and hunters where you're all very knowledgeable about firearms, but I know there's some confusion. I certainly know there is in law enforcement. So you hear yellow flag, red flag, blue paper, white paper. You know, you have an intersection between mental health and firearms, and I want to start with when you're actually prohibited from possessing a firearm as a result of your mental health. So I'm going to throw out some statutes, and they'll reference them here in the PowerPoint. But you're in the Mental Health Code, Title 34B, and you start with 3862. That is the protective custody statute. We're going to come back to that. And then you go next door is 3862A, which is the yellow flag. Now, yellow flag is not a legal term. It's a colloquial term. They're called extreme risk protection orders, or we call them weapon restriction orders. But the official name of the statute is ERPO. It changed. It was protection from substantial threats, and then it changed August 1st. We're going to come back to that. We're going to go to 3863. 3863 is an emergency and voluntary hospitalization statute, where a person, if they present at a hospital through a couple different means, but let's say law enforcement brings them into protective custody, a medical practitioner can do an evaluation, and in their expert medical opinion and diagnosis could determine that they need to be involuntarily admitted on an emergency basis to be treated. And Ben can probably speak to that process far better than I can. But once you're blue papered, the medical practitioner has to fill out an application. A judge or justice of the peace has to endorse it. And once they're endorsed, they can be held for a period of time. I think it's 72 hours, after which, if they want to continue to be held, they have to have a hearing. So there's a due process element. If you've been blue papered, you are not prohibited from possessing firearms. You used to be under federal law, under the Gun Control Act, under 922G, U.S. Code 18, up until you had the Raylander decision in 2010. That was a First Circuit decision that said you'd never been prohibited for blue paper under state law, but under federal law, they said you were up until 2010, and they said, no, you're not. So blue paper, you do not lose your firearm rights. It might be prudent and reasonable to make sure you don't have access to firearms until you get treatment, and that can be done by working with family, but as a matter of law, you are not prohibited. So, if they want to continue to hold you after that time period, they have to have a hearing before a judge. There's a due process element. So, they have a hearing before a judge, and the hospital represents one side, and I'm oversimplifying this, and then I don't want to call them the defendant because they haven't committed a crime, but the patient is represented by counsel, and you have a hearing before a judge to determine, do we need to continue to hold this person for up to the next 21 days? And after that hearing, if a judge determines that they feel that the person should continue to be involuntarily held and enters a judgment, they have then been white papered. Once you have been white papered, you are prohibited for life from owning or possessing firearms under both state law, under Title 34B, 3864, and Title 15393, and federal law, once you've been white papered. So there's no yellow flag yet here. This is all just laws that existed before yellow flag that still exist now. So that is what a white paper is. I don't think there are a ton of white papers. I don't know what the frequency is, but it is a process. It does exist. Yellow flag, we'll get into that next. Red flag, I think you've heard it talked about. That is, Maine does not have a red flag, but I think all of you know red flag, essentially what it means is who can initiate the process for this weapons restriction order. A yellow flag is limited to law enforcement. Law enforcement initiates this process. In some other states, like New York, you have a red flag where multiple people can petition the court for a weapons restriction order. So that's kind of the main difference. There's some other differences, but that's really the main one, is how does this get initiated and how does this happen? Maine, it's through law enforcement, with the information and help of family members and friends and concerned people. So does that make sense on the firearms and the white paper, blue paper, all the different color kaleidoscope? Any questions on that?
Can I have one?
Yes, please.
So I put up on the screen the definition, the statutory definition of a mentally ill person. And so we're going to get into that a little bit more. But what you'll see is it's not a diagnosis. It's more akin to a collection of behaviors that includes a person suffering the effects of substance use and a person in crisis. There are a couple of rule outs. We'll get into those rule outs more later. But I think that's one of the areas where we have a lot of confusion, is that there has to be a diagnosis. This person has to have a clear mental illness. If you look at this, and then you compare it with the weapons restrictions that you see, you understand a little bit better how things fit together. Questions about that? This is the same standard for a blue paper, an emergency involuntary hospitalization. So you have protective custody, probable cause, a person is a mentally ill person who poses a likelihood of serious harm, and then hospitals have the same criteria for the blue paper.
Thank you. Okay, so I told you we'd kind of come back to 3862 in protective custody. So protective custody is a necessary threshold element to initiate this process. If you don't have protective custody, it doesn't happen. Now, there was a change in August 1st where it extended the time frame in which these evaluations and applications can take place. But it's important to remember that law enforcement and protective custody is how this process is initiated. If someone were to present at a hospital or a family member were to bring them in, it doesn't happen unless law enforcement comes, fills out the application, and presents it to a medical practitioner, which is 99 times out of 100. Can't imagine any other way we do it, Sperling. So law enforcement and protective custody. So protective custody is a statute, 34B 3862, that has been around for a long time. It's been around at least as long as I've been in law enforcement. And essentially what it says, and we'll get into the legal terms, that if law enforcement has probable cause to believe that based on a mental illness, that you present a likelihood of serious harm to yourself or others, we can take you into protective custody. I don't like to use the term arrest, but to keep it simple, it's almost like a mental health arrest, but I don't want to make it sound like we're criminalizing mental health. But we can, sometimes it looks like an arrest. We try to work with them and be cooperative, but sometimes they have to go. We have to use a reasonable degree of force to do it. But we can take them into custody to deliver them to a medical practitioner like Ben, who's a subject matter expert, to do an evaluation.
I would just add, I don't qualify as a medical practitioner.
Gotcha. Well, he's still an expert. So we would take them to a medical practitioner where they would be evaluated. That assessment, that mental illness that he put up there in our assessment, is a layperson assessment. When I go there as a police officer or a private citizen is saying, I have concerns about my parent, my child, a family member, or friend, that to satisfy that prong under protective custody, that's a layperson assessment. As much as I like to think I'm really smart and I know everything, when I'm making this mental illness, that's as a layperson. All right, that's a common sense approach of what I think a mental illness is. The experts, the medical practitioner, they're going to make the medical practitioner assessment under the statute. So, likelihood of serious harm. Basically, do I have probable cause to believe that you're a danger to yourself or others? Are you suicidal, where you may kill yourself, or may you kill somebody else, or are you a danger to inflict serious bodily injury on somebody else? Okay, that's essentially what it means. Now, probable cause. How is that developed? Probable cause is a term that we're very familiar with in law enforcement because it's the burden of proof that you need to justify making a criminal arrest or getting a search warrant. Okay? It's a very workable standard in the field. And I think Ben has the definition up here, but I'm going to try to remember it when I was in the academy without looking. It's a little different. But basically, probable cause, and I'll give you the street definition. Those facts and circumstances within an officer's knowledge of which he has reasonable, trustworthy information sufficient in themselves to warrant a person of reasonable caution in the belief that a person has a mental illness and poses a likelihood of serious harm to themselves. That's essentially what it is. Now, what does that mean? It's a fair probability. All right, it's a fair probability. On the spectrum of evidence scale, it is probably somewhere between 30 and 50%, probably closer to 35, 40%. So the way I look at it is I have, at the very beginning, reasonable doubt. That's what you need to inject in a criminal trial in order to be found not guilty. Next up from that, you have reasonable articulable suspicion. That is a legal term in law enforcement that we use to justify doing an investigative style detention. Next up to that is probable cause, where you need to make an arrest. Up from that is proof by a preponderance of the evidence. That is more likely than not. That's 51%. Next to that, you have clear and convincing evidence, which is important because that's the standard of proof you need to meet to get irrestricted for a year. And then you have beyond a reasonable doubt, which is the burden of proof you need to meet in a criminal trial. And then you have absolute certainty, which you never have in law enforcement.
So how do you do this? Pretty darn good.
Okay, yeah, so that's kind of the spectrum of evidence scale that we
I
use.
want to jump in here real
Yes.
quick. This is a key element of the difference between red and yellow flag. Under a red flag, they use lower due process standards when taking a person's rights. Clear and convincing evidence is, as you can see, a pretty high standard. And that's the terminology that's used in our law. And it is kind of the point of contention in battling.
I think the clear and convincing evidence is for an extended restriction. The initial restriction is where the difference is. Are you comfortable with me going into that?
Yeah, I would like to see you do that, because this is a part where it's easy to get confused if you don't understand the differences between these standards.
Sure.
So reasonable articulable suspicion is a traffic stop. That's one way to think about it. Probable cause is what you need to start a weapons restriction process, to take a person into protective custody. And it's what a reasonable person would believe given the facts and circumstances. And so you are all reasonable people. So that's the standard that law enforcement needs to establish. They need to have clear facts and circumstances that allow them to do that. The difference between red flag and yellow flag, and I'm not weighing in on one side or another, is how you get to that initial restriction. So in Maine, that initial restriction involves protective custody and then an assessment by a medical practitioner. And then within 30 days, you go before a judge for an extended restriction. And that extended restriction can be up to a year. That's where the district attorney needs to demonstrate clear and convincing evidence to extend the restriction. For red flag, the initial restriction can be based on a layperson going to a judge. Oh, I got John Chapman here. He's probably going to yell at me for something. Do you want me to put you on speaker, sir? All right, I've got John Chapman, my former neighbor, on the phone here. So, John, what I'm explaining is the difference between an initial restriction and an extended restriction and how that plays into due process. So that the initial restriction in Maine involves protective custody and assessment by a medical practitioner. In red flag, there isn't those two steps. It goes to the initial restriction, but then you still have the clear and convincing evidence for the extended restriction.
Sure. By the way, just for everybody in the room, Ben is truly a rock star in this area, and I've been very impressed by him as more than a neighbor.
Thank you, sir.
Well, no, but to stay on that point, I guess, is, so probable cause is the burden of proof that you need to initiate this process. There's a gap between probable cause and clear and convincing evidence. So your initial period of restrictions, which can be up for 30 days after which you have a hearing, it means that you may be able to get an initial period of restrictions of 30 days, but you may never have the evidence that you need to prevail at a hearing. So there could be various reasons why you get an initial period of restrictions for 30 days, but you either don't prevail at a hearing or a DA decides not to file a petition at a hearing because they feel that they can't meet that burden of proof to prevail. So there are reasons why you may only get a 30-day initial period, but you don't prevail at hearing and they don't get the year-long restriction. That 30-day period is still very valuable. That's incredibly valuable when you look at the people that are in crisis that this law is being applied on. That still provides time, a cooling off period, a time for treatment, a time for them to get some help, regardless of whether or not they're going to be restricted for the full year, or the DA and council come to an agreement where they decide we're going to do it for maybe 5 or 6 months. But anytime you have a gap between what law enforcement is doing in the field and what may happen in a courtroom, it doesn't mean that the initial period of restrictions weren't legally righteous. It was, but probable cause is different than clear and convincing evidence. There's a pretty wide gulf between there. And you don't see clear and convincing in the criminal world, but this is a civil process, not a criminal process. It's a civil process with a criminal penalty. So you can't really apply the same terms. It's different in that respect. So that's why probable cause is important. It's what you need to initiate it and get it going, but you're going to need more when it goes to a hearing to meet that burden of proof.
May I have one thing?
Yes.
So I think that's one of the other important pieces for community members to understand, is that when you're working with law enforcement, when you're concerned, you need to be able to provide them with more information than simply saying, I'm concerned. We need to be able to help them establish the facts and circumstances that allow them to take somebody into protective custody. So much of the work I do with community providers and other community members is help them understand what it is you need to explain to law enforcement so they can do their job. Does that make sense?
So we talked about protective custody and probable cause and how you formulate probable cause. Well, probable cause can be formulated a number of different ways, but the protective custody statute specifically says that in law enforcement's formulation of probable cause, they can rely on credible and reliable third-party information. So if you speak to a family member or friend and they're providing credible and reliable first-hand observations of the person that they're concerned about, you can use that in developing your probable cause. The key is that it's credible and reliable. Probable cause can be based on hearsay. This hearing, you can use affidavits and hearsay information. It's a civil process. You can't use hearsay in a criminal trial unless there's an exception to the hearsay rule. But this is different. You're allowed to use that. So let me give you an example of I'll de-identify a situation in which you can see this actually works, because in speaking with all of you folks, you're thinking, all right, you see people that may have undiagnosed, untreated mental illness, and unfortunately we're at a point where, whether it's because of lack of community-based treatment sources or challenges in that field, you're almost like waiting for something bad to happen before you can take action. If you are seeing things that concern you, okay, then you call law enforcement and you speak to law enforcement and you tell them what your concerns are and you try to provide them as accurate and detailed information as possible based on your firsthand observation. This is how he or she is behaving. This is what they've said. This is what they may have posted on social media. And then we'll look at that and evaluate, okay, are we starting to get to maybe probable cause to believe this person is a danger to themselves or somebody else based on a mental illness? Okay, now law enforcement's going to follow up and probably do a welfare check, and they're going to want to corroborate or supplement your observations with their own first-hand observations. But almost all the time, it starts with a family member or friend being concerned and calling and reporting to law enforcement, and that call is so critical. That is incredibly critical. It's kind of like the kind of see something, say something campaign. If you see something that is concerning you, then call law enforcement. And I understand people may feel like, I don't want to call the cops on someone, this is a mental health issue. But like I said, we're in a post-Lewiston world. We're in a post-Lewiston landscape. And if you have concerns about that person, you need then report it to law enforcement, because law enforcement have the tool now with this law to be able to follow up. And if we meet the dangerous weapon component and the probable cause component, we can do a weapons restriction order application. So, give you a situation. We get a call. Oftentimes these cases are initiated by family members, and it's key. It's a spouse, it's a parent, it's an adult child calling about a parent. It is so key to not only the reporting, but following this all the way through, dealing with the weapons relinquishment, dealing with the care of that person. We get a call from a woman who has an adult son that lives with her. And she is concerned because that person has a history of suicidal behavior. And she's noticed changes in her son's behavior. So adult son lives with her, and she reports that to law enforcement. Law enforcement may speak to her on the phone or speak to dispatch. They may go to the residence and do a sit-down conversation with her and say, why are you concerned? Well, he just got done work. He lost his job. I noticed he doesn't he's not doing his normal activities. He's tried to commit suicide in the past by overdosing on pills. He's talked about life isn't worth living. He hasn't been very specific necessarily about how he's going to do it, but I'm very concerned, and I've observed him over the past 3 or 4 weeks. Now, would you say that the mother is just on its face would be a credible, reliable third party? Just without law enforcement training, just common sense, credible and reliable third party. The information she's providing is that have some specificity to it about the person's behavior. Would you say that, yes, I've got a concern, this person maybe has a mental illness, there may be a danger to themselves, just common sense, reasonable person? Would you say yes? Yes. Now, whether you're at probable cause or you're scratching at the door of probable cause, this is a third party that's reporting to law enforcement. Now, law enforcement goes and speaks to her and then wants to talk to the subject, talks to the subject at the table, confirms that this gets additional information. This person says, yeah, life isn't worth living, acts very despondent, things haven't been going my way lately, I've been thinking about killing myself, I'm not exactly sure how I'm going to do it, but I really have been thinking about taking my life. Okay, without going into other details, is there a fair probability that you believe that that person has a mental illness and that they're a danger to themselves? Yes or no?
Yes.
Yes. The answer is yes. That's probable cause in a basic workmanlike form, okay? Now, there's an additional component about the dangerous weapon, and I don't know if we want to talk about that, Ben. I don't know if I'm getting ahead of myself. I don't want to brush over the probable cause third party if we want to get into the dangerous weapon component.
So I think at this point, this is a lot of the education we do with law enforcement. So at this point, you've established probable cause. This is a mentally ill person who poses a likelihood of serious harm. Does that make sense? So now law enforcement is able to take that person into protective custody. If they take somebody into protective custody, and it's law enforcement may, so if they do, they have to deliver that person for assessment by a medical practitioner. So once we've established all of those things, there's one more thing that you need to meet for a weapons restriction. Probable cause the person possesses, controls, or may acquire a dangerous weapon. Now, is this somebody that you would be concerned about having access to a weapon at this point? So you need to ask a few more questions.
Yeah, so we've established we have protective custody and probable cause. And now we're gonna, like Ben said, we're gonna talk about the dangerous weapon component. If there's no dangerous weapon component, then this is like the protective custody statute that has existed for a long time. You can take the person into protective custody, deliver them to a medical practitioner to be evaluated for treatment and evaluation, which might lead to a blue paper, might lead to outpatient treatment, whatever. Whether taking them into protective custody is a discretionary act. The statute says may. If there's no dangerous weapon component, you're in the may territory. You're not compulsory. It's not a shall. Okay? So you may decide to take that person to protective custody. You may not. If they're willing to go with their mom and dad or willing to go in the back of an ambulance, then there's no sense of having law enforcement try to necessarily aggravate the situation or escalate it when it might not be necessary. They're willing to go to the hospital, see a medical practitioner, get evaluated. That is the key. Now, the dangerous weapon component, as Ben said. So the yellow flag statute, 3862A, it's right next door to protective custody. It's a good fit for it. There's a definition in there. It's a definition, but it's really important. It's under 3862-A, subsection 1, paragraph K. It defines a restricted person, and this is key. If you have probable cause to take a person into protective custody because they present a likelihood of foreseeable harm, and you have probable cause to believe that they possess, control, or will acquire a dangerous weapon, yellow flag. Now it's not discretionary, it's a shall. You shall take them into protective custody, and you shall fill out a weapons restriction order application. Okay, now law enforcement is always going to have a certain amount of discretion to deal with the situation because the laws are black and white. We live in a world of gray where you need that discretion. But just legally speaking, generally speaking, law enforcement, you shall take them into protective custody. It's no longer a discretionary act. Again, post-Lewiston world, with all the liability and public safety concerns, you're going to do a weapons restriction order. Now, a little bit about what constitutes possession, control, and acquire, because these are important terms and they're kind of legal terms of art in terms of what they mean. Possession is just what it sounds like. It's actual possession. You have a dangerous weapon on or about your person that's readily available. Control is another word for constructive possession. Constructive possession is basically you have knowledge of the dangerous weapon and the ability to exercise control over it. Acquire is just that. You've indicated, based on the information, your intent to acquire a dangerous weapon. So those are kind of the three terms. Now, this law applies to possession, not ownership. Okay? You can possess something and not own it. And you can have an ownership interest in something without necessarily a possessory interest. I know that seems a little weird, but ownership, I think, is a component to determining possession, but you don't need to own something to possess it. This law applies to possession. That's key, is that it's possession. What is a dangerous weapon? A firearm is always a dangerous weapon. So if a dangerous weapon has a very specific definition in the criminal code. It's under 17A, section 2, subsection 9, paragraph C. Dangerous weapon always includes a firearm. Anything else could be a dangerous weapon based on the manner in which it's threatened to be used, and based on that can cause death or serious bodily injury. A baseball bat is not a dangerous weapon unless you threaten to hit someone with it. It becomes a dangerous weapon. A steak knife is not a default dangerous weapon unless you threaten to stab someone with it. Then it becomes a dangerous weapon. A firearm is always a dangerous weapon under Maine statute. We good on that so far? Okay. So, made the determination at the house, talked to the person, clearly suicidal. How do I determine the dangerous weapon? How do I determine that at the time I'm dealing with them, they possess, control, or will acquire a dangerous weapon? Well, you have to do an investigation and ask questions. You may ask them, do you have any firearms in the residence that you have access or you possess? And then see what they say. Are there other dangerous, if you're asking them how are they going to commit suicide, have they thought about it? Have they thought how they're going to do it? And they indicate that, yeah, they're going to go and they're going to get a knife and they're going to stab themselves. Or they're going to go and try to acquire a firearm. Then that would satisfy that element. So you're going to have to speak to them. You're going to have to see if there are any things in plain view that I would consider to be a dangerous weapon. The key thing that and this is more for law enforcement, but it's a key thing. You don't need to show that you have probable cause to believe they are going to use a dangerous weapon to kill themselves or hurt somebody else. There's not a causation element in here. There's probable cause to believe mentally ill, danger themselves or others, and probable cause to believe that you possess or control a dangerous weapon. So let me give you an example of that same.
Or may acquire.
or may acquire. May acquire. They may. If I had someone that is a danger to themselves, they don't indicate they possess a dangerous weapon. I have no evidence to indicate to the contrary. But in telling me, well, I'm going to go out and commit another Lewiston. Well, by inference, a Lewiston was obviously committed with a firearm. That would satisfy the probable cause problem. If they're referencing going out and engaging in an incident that we know factually involved the use of a firearm, from a law enforcement perspective, then I would consider, yes, you have indicated your intent to acquire a dangerous weapon, to wit, a firearm, and I'm going to use this law is going to be applied. To get back to the scenario I was talking about, where adult son living with a mother, concerned about suicidal behavior, he reaffirms that, he talks about it, you've established protective custody, mentally ill, danger to himself. In speaking with that subject, let's say that yes, I own a handgun. I keep it upstairs. It's my handgun. Said I would never use it to shoot myself. I would never do that. But I have a handgun. Okay, let's stop here. We've agreed we have probable cause, protective custody. Now, common sense, reasonable person. Do we have probable cause to believe that person possesses, controls, or will acquire a dangerous weapon? Yes. That's a yellow flag. That's a yellow flag. That didn't happen in this case. If they indicated, I'm going to take a knife and I'm going to slit my wrists, stop there. Probable cause to believe that they're mentally ill and a danger to themselves? Yes. Probable cause to believe that they possess, control, or will acquire a dangerous weapon? If you take a knife and you slit your wrist, is that in the manner in which it's threatened to be used to cause death or serious bodily injury? Yes. That's a yellow flag. Now, the downstream question, are we taking every belated thing in the house? Not necessarily that's a reasonableness, but that they've indicated their intent to acquire something that in the manner in which it's threatened to be used is a dangerous weapon. That's a yellow flag. For law enforcement in the field, probable cause, we're going to fill out an application. Is everyone with me so far?
It's been used to take machetes and...
Oh, yeah.
Go ahead.
Yeah, could you just clarify a little bit more the may acquire part? It seems kind of subtle, but do they have to express that they intend to acquire?
Yeah,
or is there some gray in there?
Well, so you need to have probable cause to believe that they possess, control, or will acquire a dangerous weapon. So you need to have detailed information that they have an intention to go out and acquire a dangerous weapon. So that can be discovered a variety of ways. Mostly it's discovered by speaking with the person. How do you satisfy that element? But if they indicate to you their intent to go out and acquire a dangerous weapon by telling you or referencing they're going to engage in an act that where a dangerous weapon was used, then that's probably going to satisfy that problem.
But it can't just be assumed.
No. Probable cause. So probable cause we talked about. It can't be an unspecified hunch. It can't be based on your spidey sense. Okay, probable cause, you need to have specific facts and circumstances, which you can draw inferences from based on your training, education, experience, but you can't just make an unspecified hunch or, well, I think they're going to do it. No, it needs to be grounded based on the evidence that you have in front of you, which could be a statement from them, a statement from a third party, it could be based on text messages, social media postings. It needs to be grounded in that in that soil of information. Does that make sense?
Yeah, thank you.
An example of that might be, I'm going to go get Uncle Joe's gun and kill myself. Or
Yes.
That's
All
an
day long.
example of may acquire.
Yeah, that's obvious, but
Yeah.
Yes, all day long, exactly. That's
So I think the all day long is really one of the essential points of this, is when you look at the list, it's all day long. These are not questionable circumstances. There's nothing that's gray or ambiguous in any of the weapons restrictions that we've seen. These are based on probable cause statements from law enforcement. They're not going to come to us unless they've already established that probable cause. And so in this case, that idea of I'm going to go and get Uncle Joe's gun, or I'm going to the store, oftentimes we've got text messages or social media posts that are part of that probable cause statement that are being delivered to us. So law enforcement is doing a truly incredible job of gathering and packaging this information. And then we're able to see it and say, oh yeah, this makes sense. This is really, really clear. But I encourage everybody who's really looking at the weapons restriction process to take a look at the list, because there's nothing on that list that anybody here will have any questions about.
That list was provided by the Attorney General's office.
Yes.
So let let me give you another example of kind of a third-party report that, of this, that where we didn't actually have an encounter with the patient. I'll use the word patient because, you know, while you can initiate this process, while there's also criminal liability, it's not an either or, but a lot of times there's not necessarily any criminal liability, it's just mental health. So we dealt with a call where we, a family member, I think it might have been a sister, was concerned about her brother. So she's an adult, he's an adult. She calls up and says, I've been communicating with my brother via text message, and he said some things over text message that are very concerning and indicated that he might be a danger to himself or other people, and talking about a weapon. So we go and we speak to her, and she shows us the text messages where the person has talked about that he might hurt himself or might hurt others, and he might use a knife to do it. Okay, so he's telling her this, and she's also telling us that he has substance use disorder, mental health, so he has co-occurring disorder, and you know, she gives very detailed information to law enforcement. So law enforcement goes and interviews her. She lives in Hancock County, and this person's last known address, I think, was in Penobscot County. Kind of a transient, not sure. So, but she tells us this, and she gives us this information. Yes, yes. And so we talk to her, we see the text messages. So again, probable cause, fair probability, something less than 50%, common sense, reasonableness. Sister showing text messages from her brother that indicates that he's thinking about killing himself or hurting others, might use a weapon to do it, and she also provides background on his mental health status. Do you think that based on that, you have probable cause to believe that this brother is a danger to himself or others? Yes, we determined we did. We haven't spoken with the brother yet, but it was so, if the text messages and the sister, recent communications, and is there a fair probability? Yes. So, and we don't need to get into the protective custody more unless you want to, Ben, but this involved the use of the new protective custody law. We wanted to find him and check his welfare, and because we were concerned about him and others. So we initiated a search for him to try to find him. But we didn't have a good address and wasn't sure where he was. He was a transient. And that ultimately led to us using a new portion of the law, which went into effect August 1st, called a protective custody warrant, where we had probable cause to take the person into protective custody, and we wanted to do a yellow flag or weapons restriction order assessment, and we made a good faith effort to try to locate him in the areas that he was known to frequent, but couldn't. So how do we make sure that if law enforcement encounters him later that night, early that morning, the next day, they know that he's wanted for a weapons restriction order mental health assessment? And so we applied and received this new protective custody warrant, which they have, which is a provision to make sure that these things don't slip through the cracks. Yeah, sure.
So this is probably one of the coolest new changes in the statute. And this is the criteria for a protective custody warrant, that you've made an attempt to take the person into protective custody. If you're not able to, then you can seek a warrant. The idea is that there were many instances, pre-Lewiston, where we had individuals that were refusing to come out of the house. And then what do you do in that situation? What we've seen is post-Lewiston and post-protective custody warrant, that this is a tool to help find people who are really struggling. So here's the idea, and it's a difference between the civil system and the criminal system, and I'm probably going to butcher this, so Lieutenant Johnson's going to be able to clarify it for me afterwards. But if you've got probable cause that somebody has committed a crime, you've got all kinds of options. You can detain or arrest them, you can force entry in certain situations, you can apply for a warrant. But prior to this change in the law, if you have probable cause a person is mentally ill and poses a likelihood of serious harm, your option was to take them into protective custody. Now, if you're unable to take them into protective custody, you can apply for a protective custody warrant. That gets entered into the system like any other warrant, and it allows other agencies to then take that person into protective custody.
Asterisk that, I'll talk about that, about it going in the system, but there's a solution, but I think it's a bridge to a more permanent solution.
But the coolest part of it is that we've seen people that are traveling between different areas, between different jurisdictions. And this allows you to initiate a protective custody warrant in one area and then have a law enforcement officer in another area take that person into protective custody. That wasn't the original design of this, but it's been a major improvement in the social safety net based on this very small change of the law.
Yeah, so the protective custody warrant is new. I don't think there have been very many of them. That's my troop's first experience with it.
6 or 7.
6 or 7, okay. So like with any new law, you kind of get used to it, and you kind of you get some reps under your belt, and to the extent that there may be some hiccups in it, then it might be something we have to go back and smooth out some stuff later. But in this case, it was very helpful. Absent this protective custody warrant, then really what you're left doing is just maybe sending out a teletype or trying to spread the word that you're looking for this guy, and if you find him, please contact us. But this warrant formalizes that process, and you put it into NCIC, so now there's a nationwide alert. So if a law enforcement from here to Timbuktu should happen to encounter him, they know that we are looking for him and that we have probable cause to take him into protective custody. And if you encounter him, please detain him, do it safely, and contact us to await further instructions. So it allows, it's a more formalized, comprehensive approach to these cases where you're not able to have contact or take the person into custody immediately. And it provides an option for that. Now, reference the entering into the warrant, I won't get into the weeds. I think there probably is a technology fix because they can't go into the criminal warrant database because they're not criminal warrants. So I think there's probably a technology solution somewhere behind the scenes between the courts and Metro and all those computer systems. We found a temporary solution. We enter them as a potentially missing or endangered adult, which they are, and it works for now. So that's just something that they'll have to address kind of later on.
So the question is, do you think it's a good idea to have something like this that allows people to communicate across jurisdictions? Right? Huge improvement. Huge improvement.
And let me give you an example, kind of, I mentioned it practically. With this guy, we ended up locating him within 24 hours. Another law enforcement agency had contact with him in the area, and we were able to take him into protective custody. That PD actually took him to the hospital near them, called us, we met them, and we initiated this process. But let me give you an example. Let's say that 2 or 3 days went by, and he took a bus, and now he's down in Boston. And let's say he does something down there that causes law enforcement to have contact with him. Well, despite your best efforts to send out teletypes and this and that and emails, Boston's a busy PD and they deal with all sorts of stuff. Well, if they were to encounter this guy on, let's say, some sort of benign traffic stop or something like that, and they were to run him, you're going to have an alert that pops up. Says, hey, he has a protective custody, mental health, I call it a warrant. It's essentially a warrant the way you look at it. Take him into protective custody, contact the Maine State Police, and coordinate with them for further instruction. That is the key part of it. Before this law, that really doesn't happen. Or you're maybe counting on the fact that a police agency or law enforcement agency, is that it? Yeah.
Well, no, I was just going to say, here's an example. 671, 40-year-old New York man reported to be in Bar Harbor with a firearm and intention to kill himself, subject of a New York RPO for homicidal and suicidal ideations, history of depression. And so, great use across state lines.
And that addresses some of what was found in New York with the Robert Card situation where there's cross jurisdictions, military, police. This could be a way, if it was some sort of mutual agreement with other states, that these orders, if they are initiated, and I believe they should have been, maybe red flag in New York, yellow flag here, whatever, well, that's where that communication can occur. And I know Senator Collins is working on this nationally with the military and others, a way to build that communications network across jurisdictions. But I see you've already started to address that.
Well, and the new law addresses it somewhat. I understand what you're saying, David. I think the initiative is to have a federal law that provides full faith and credit, similar to what we did to protection orders decades ago, something similar. But this law does, as part of the August 1st change, now recognize similar out-of-state weapons restriction orders.
Yes.
So now that helps us with law enforcement to say to what extent are out-of-state ERPO laws enforceable or effective here. there was a change in the definition where they added language to say similar orders from other states. So I think that's a good step in the right direction.